Hello, this is Steve Rinka from the Rinka Law Firm, and I'm here today to talk about demurrers. You may ask yourself, what is a demurrer? A demurrer is a motion that is brought by the defendant after they've been served by the complaint. The purpose of the demurrer is to try and knock out the causes of action that are being brought against the moving party, which would be the defendant. And we call that person the moving party because they're asking the court to make a motion or move this litigation in a certain direction based on a motion brought by the defendant. So the moving party could be either the plaintiff or the defendant. It's just whoever brings the motion is the moving party. Anyway, so with respect to a demurrer, you have to file it right at the beginning of the lawsuit. If you file an answer, which is also a viable response to a complaint, you waive your right to bring a demurrer. By bringing a demurrer, you're telling the court that based on the allegations set forth in the complaint, there is no possible way that the defendant has committed anything wrong based on the causes of action being brought before it. Now, some of the reasons that you may bring a demurrer is because the statute of limitations has run. So, for example, defamation has a 1-year statute of limitation. Let's claim that the alleged defamatory statement occurred on January 1, 2018, and the plaintiff sues the defendant on January 5th, 2019. Well, 1 year has passed, and the date of the defamatory statement is something that is easy to state, easy to show when that occurred, and it has to be set forth in the complaint, and then you know when the complaint was filed because it'll be stamped on the complaint itself. So based on when the defamatory statement occurred and when the complaint was filed, you can determine that more than 1 year has passed. So what you would do is you would bring a motion before the court saying, Your Honor, this complaint should be dismissed against me, i.e. the defendant, because the defamatory statement took place more than a year prior to the filing of the complaint. There is nothing that the plaintiff can do, even if the court were to allow the plaintiff to amend the complaint. There is no way they could fix this defect, so therefore the court should dismiss this complaint against me, i.e. the defendant. And in that situation, there's a very good chance that the court will dismiss the complaint and that party would be out of the lawsuit. Now, you can also make allegations or bring a demurrer based on the fact that the plaintiff has not alleged sufficient facts to bring a cause of action against the defendant. And that's certainly viable. That's certainly a proper basis to bring a demurrer on. However, in all likelihood, what's going to happen is the court, if you do make a proper showing, could grant the demurrer, but the court is going to allow that party, the plaintiff, to file an amended complaint. Now, in all likelihood, the amended complaint may not allege sufficient facts, and again, the defendant will bring another demurrer to the complaint saying, Your Honor, even after giving the plaintiff an opportunity to file an amended complaint, they still have not alleged sufficient facts to state a viable action against me. Therefore, the court should grant my demurrer and dismiss the complaint. And there's a good chance, let's say, that the plaintiff doesn't allege sufficient facts, that the court will grant the demurrer. But in all likelihood, the court's going to give the plaintiff another opportunity to amend the complaint. It's only in situations where there is a real clear basis that the complaint is improperly pled or there's certain defects that are insurmountable for the plaintiff that the court will just go ahead and not give the plaintiff another opportunity to file an amended complaint. But if it's just stating that there are insufficient facts, the court is going to give that plaintiff 2-3 times an opportunity to amend the complaint before the court finally says enough's enough. Giving you 3 opportunities, and you, plaintiff, have not been able to allege sufficient facts. Therefore, we're going to dismiss the complaint against this party, the defendant, and that's it. You're done. You're out. And then you can potentially go and seek costs against the plaintiff, namely the filing fee that you're required to pay when you file an answer, which in Los Angeles County Superior Court is $435. And there may be some other costs that you might be entitled to recover in the event that your lawsuit is dismissed against you. So the important thing to remember about a demurrer is you have to file it out of the gate. If you file an answer before you file the demurrer, you waived your right to bring a demurrer. Now, there's going to be other opportunities down the road where if you're the defendant, you can bring a motion to try and get the lawsuit dismissed, such as a judgment on the pleadings motion or a motion for summary judgment. Those are some other matters that I will discuss later on. Also, one other important key. When you are going to be filing a demurrer, in California, the California Code of Civil Procedure requires the moving party, i.e. the defendant, to meet and confer with the plaintiff prior to filing the demurrer. So what this means is the attorney for the defendant or the defendant, him or herself, must contact the opposing counsel and let them know, hey, I'm going to be bringing a demurrer, and explain to the opposing counsel why you're bringing this demurrer. Namely, hey, the statute of limitations has run, you have no basis to bring this cause of action against me, and I'm going to bring a demurrer, and the court is likely going to grant it. The hope is that by meeting and conferring with the opposing counsel prior to filing your demurrer, it'll eliminate the need for the court to get involved, because if it is a very straightforward matter and the defendant points out to the plaintiff's counsel, hey, there's nothing here, hopefully the plaintiff's counsel will either dismiss the defendant or file an amended complaint, in which case you may have to file another demurrer. But again, if you do that, you also have to meet and confer with the plaintiff's counsel again before filing a second demurrer. But that's something that's very key, because if you don't meet and confer, the court could get very upset and deny your motion just for failure to comply with California Code of Civil Procedure. So that's something very important that you want to keep in mind before filing a demurrer. So if you have any further questions about demurrers, you can contact me, Steve Rinka, at the Rinka Law Firm at 310-556-9653. Thank you.